This is Group 9's presentation on constructive trust.
As a relationship, this arises whenever a person called the trustee is conferred in equity to hold property for the benefit of some other persons who are called the beneficiary, of which he may be among, and in such a way that the real benefit of such a property accrues not to the trustee but to the beneficiary, which is the express trust, the implied trust, and the constructive trust. A trust is said to be express when it is from the true intention of the owner, and it can be made by conveyance or by a declaration in a will by the settlor. It is said to be implied when it is presumed from the intention of the owner, and a constructive trust is one which is imposed by the law, not minding the intention of the owner.
Trust implied by the courts to prevent unjust enrichment based on the rationale that a man must not be allowed to enrich himself at the expense of another, even though there is no fiduciary relationship.
Constructive trust is imposed by equity on the grounds of good conscience. It is not based on the prior or presumed intentions of the parties. As seen in Kotoya against Saraki, constructive trust is based on good conscience and it is not based on the prior intentions of the
Where the
parties.
court will be forced to invoke the principle of constructive trust to a third party from the trustee, whether with actual or constructive notice that the transfer is in breach of a trust. Such stranger becomes a constructive trustee for the beneficiary.
The formula through which the conscience of the court is expressed when the property has been acquired in such a way that the holder of the legal title has not retained it to the beneficiary in good conscience. The court converts them to be a constructive trust.
Where a trustee makes a profit from the possession of a trustee, then it becomes a constructive trust of the profits made. This simply means that whatever profit a trustee makes during his position of being a trustee, then such property will be held on behalf of the beneficiary. It can only become a constructive trustee, that is, a person who simply holds it on behalf of the real beneficiary. So no matter what profit is trying to make, it is still on behalf of the main beneficiary.
Where a person in a fiduciary relationship unjustly enriches himself, as in the case of Nasir against Benin,
He sells mortgage property. It becomes a constructive trustee of surplus money after deducting his money and interest, as seen in the case of Charles against Jones.
When property has been acquired in such circumstances that the holders of legal title may not in good conscience retain the beneficial interest, equity converts into a trustee. This basically means that where a person unlawfully retains the property of another in some circumstances, will be held to be a constructive trustee on the behalf of the original owner. This is evident in the case of Kotoya and Saraki, and also in Ibeko.
Thank you for watching. Bye.